Hi, this is Alan Gassman, and you are here today for the Asset Protection Tune-Up. It's the same old stuff I've done before with a different name and a different cover. I have taken my materials today from a recent talk I gave for David Finkel's Maui Mastermind program. It was a May 23rd 1-hour webinar. I'll be saying a few things today that I did not say then. I said quite a few things then that I will not say today. If you'd like a free copy to review what we did for Maui Mastermind on May 21st, just let me know, send me an email, and we'll be glad to share it. I've got a lot of things to cover in the next 30 minutes, also known to many of my clients as 3/4 of a billable hour, as we jokingly say. And I was really, reflecting on Bob Dylan's song, Hard Rain's Gonna Fall. And those of you who were early got to hear a little bit about that song. It's a beautiful, beautiful song, and it really fits in with what my friend, Professor Dennis Kleinfeld, says whenever he starts a talk about creditor protection. It was not raining when Noah built the ark. Remember? He built the ark and no one was worried. He was worried, and he got all those animals ready to go into the ark. And then lo and behold, it did rain, and it rained really, really hard. And we are here in the midst of what I call this virus freeze. The government is printing plenty of money for almost everybody, except for the bar owners and the restaurant owners. Landlords are not allowed to file evictions. Everyone's being very nice and very friendly. But the bankruptcy lawyers tell me that they have lots of lawsuits and lots of bankruptcies ready to go for when this thaw happens. And my concern, and the concern of many others, is that this economy could launch into a recession that would make 2007 and 2008 look really gentle. So we have a lot of people who have a lot of debt, a lot of long-term leases, a lot of businesses that may not do so well, and therefore creditor protection is really important. Definitely be building your ark so that you have your escape hatch if you need it. Now, the language of any subject is normally the key to understanding the subject, and creditor protection is no exception to that. The debtor, of course, is the person who is owed money. The debtor is the person who owes money or the entity that owes money. The creditor is the entity that is owed the money. A judgment happens when a court declares the money to be owed. I may owe you a promissory note or owe you under a lease, but you cannot start a collection action against me in the vast majority of circumstances unless you have a judgment against me. And it can take a year, 2 years, 3 years to get a judgment. And until then, things can be done by a debtor, which may cause the creditor to have difficulty collecting. Now, the assets that a creditor can reach are called the non-exempt assets. In my individual case, if I have money in a bank account in my name, I have my own jewelry, I have my ownership in my legal practice corporation. Those are non-exempt assets. If you get a judgment against me, you can have the sheriff come get them or otherwise levy upon them. On the other hand, though, I have exempt assets. The law says that an exempt asset cannot be touched by a creditor under most circumstances. An exempt asset would be my pension plan, my IRA. Under Florida law, the 529 plan I set up for my granddaughter's education, my annuity contracts, my life insurance policies that have a cash value. These are exempt assets under Florida law. And there are also federal exemptions, which include tenancy by the entireties, which we'll mention more about later. Now, the hottest topic in this type of situation where people don't expect to become debtors, but suddenly they are, or they didn't plan ahead, is the question of a transfer to avoid a creditor. A transfer made for the purpose of avoiding a creditor is normally called in our profession a fraudulent transfer. And that is a real misnomer because fraud is a very bad thing in the law and in the world. When you commit fraud, it means that you mislead someone for the purpose of taking something from them, and you actually take something from them. You defrauded them. You said, Floyd, give me $100 and I'll give you this box with a working radio. You know there's no radio in there. It's a brick. Floyd gives you the $100. You give him the box. You're nowhere to be found. You are guilty of fraud. It's a felony. It's a criminal event. On the other hand, a transfer to avoid creditors is not always a criminal event. The laws of Florida, New York, and many other jurisdictions are very clear that there is nothing illegal or nothing that would punish you under the law for making a transfer to avoid a creditor other than the consequences of the fraudulent transfer statute, which in most states says that if you committed a transfer for the purpose of avoiding a creditor, the creditor can chase the asset. The creditor can get the asset back out of the 529 plan, get it back out of the annuity, get it back from your grandchild who you gave it to, and collect attorney's fees and costs. But it's not a crime. And the creditor has to prove that it was a transfer for the purpose of avoiding a creditor. And there are many cases that have been very kind to debtors. For example, there's a bankruptcy case where a farmer had intended to give his house to his mother for several years. She had given him the house and he needed to give the house back. And he just didn't get around to it. His lawyer told him to do it. His accountant told him to do it. He didn't get around to it. Suddenly, he had a judgment against him. He goes to the University of Kansas bankruptcy clinic to get free advice, and they tell him, hey, give the house to your mother like you promised and go bankrupt. He gives the house to his mother. He goes bankrupt 3 months later. If you commit a transfer to avoid creditors less than a year before you file bankruptcy, you lose all your right to bankrupt out all that debt. That debt stays with you usually for 20 years. It could be longer. So this farmer was in a really bad situation. The bankruptcy judge could have said, hey, this was clearly to avoid creditors. You don't get a discharge. You owe this creditor until the statute of limitations on the judgment runs, which is 20 years normally. Instead, the judge said, well, you know, Mr. Farmer, I know why you did this. You did this because you promised your mother. You had an ethical obligation. You didn't do it to avoid the creditor. That seems clear to me. So the farmer got to keep his farm and got to go bankrupt, got the judgments away, lived on his mother's farm, happily thereafter, I hope. Many, many debtors come to Florida to make a transfer to avoid a creditor, especially if they live in California, Connecticut, or one of the other states that will actually punish an individual and punish a lawyer for helping an individual commit a transfer to avoid creditors. In Florida, our constitutional protection of our homestead is so strong that if you come to Florida and transfer your assets into a homestead, which qualifies as a protected homestead, unlimited value, up to half an acre within the city limits, up to 160 acres outside the city limits, you do that for the sole purpose of avoiding a creditor. You even do it the day after a judgment, and sometimes this happens. The creditor cannot set aside that transfer unless the transfer was of bad money. In other words, you took money, you fooled somebody and you took the money that you took from them, put it in the homestead. That's not going to work. But if it's your money from prior situations, you sell your business in Connecticut, you move to Florida, you find the home of your dreams, you buy it, tough luck, creditors. The creditor's only remedy would be to force you into bankruptcy, because there's a 10-year look-back rule in bankruptcy. But it takes 3 creditors to force you into bankruptcy if you have 12 creditors, and it goes on and on and on. I find it to be very interesting. Creditors know that they may not get paid. Even if it looks bleak for you as a debtor and you owe a creditor a lot of money, the creditor knows, or should know, that you might just move to Florida, buy a big home, and wait 10 and a half years or 10 years and a day and bankrupt them out. So there's always going to be hope. Page 5, joint and several liability. If I sign a note, you sign a note, our friend signs a note, 5 of us sign a promissory note, and then we can't pay it, and I say, here, bank, here's my 5th, here's my 5th, and the bank goes, not enough, we want it all from you. Wait a minute, there were 5 of us who signed the note. Tough luck, joint and several liability. The same thing can happen. I have a partner. The 2 of us hire someone to deliver a survey to the architect's office. The architect needs the survey. The delivery person who we hire gets in an accident. We are vicariously liable for the accident because the delivery person was working for us, and we are jointly and severally liable because we were partners. This is not a good day for us. That's why we want to have our partnership not be a partnership, but instead be a limited liability company or a limited liability partnership, and why we would prefer for our delivery person to be an independent contractor and not an employee of ours. What is a secured interest? A secured interest is like a mortgage. So let's say that I loan $100,000 to my legal practice because I've been having financial problems because of the COVID virus. And I have other creditors of my legal practice. I have a lot of accounts payable, and I have one person I owe that I don't even really like. And now here I am loaning $100,000 to my legal practice. I can take a lien like a mortgage against the assets of my legal practice by signing a security agreement and filing a Uniform Commercial Code UCC 1 form with the state of Florida. And then if my legal practice has to go into bankruptcy or becomes insolvent, if it's been more than a year since the mortgage security agreement was signed, I can repossess $100,000 worth of assets from my legal practice and not have to share those $100,000 worth of assets with the other creditors if I do everything right. So the moral of that story is, if you are owed money by your company or you are putting money into your company, get a lien against the assets and document it with a bona fide promissory note. And if you owe creditors from your company, or you owe creditors individually, and one creditor is your mother and another creditor is someone you don't like, give your mother a lien on your assets so that if you have to go under, the creditor you don't like will not be able to go after or attach the assets that your mother has the lien on. Now, this assumes that you like your mother or that your mother will take good care of you. And that's not always the case. So you may want to give that lien to your mother-in-law or your father-in-law, or maybe an irrevocable trust that you set up for your children years ago. What is an asset protection trust? An asset protection trust is a special type of trust where the person who puts the assets into the trust may be a beneficiary of the trust, but creditors can hopefully not reach into that trust. The asset protection trust is the most popular and profitable product, and I'll use the word product there, that creditor protection professionals are generally using to protect people's assets. And I use asset protection trusts, but usually not, and almost never, for somebody who has an imminent creditor problem. One reason being that it may not work. Another reason being that, at least for Floridians, we have many, many alternatives to asset protection trusts that work better than asset protection trusts. So be careful. You're going to see a lot of websites. You're going to talk to a lot of people. And those who really push those asset protection trusts, we find, are typically not doing the best job for their clients. I'm going to mention automobile liability here. A lot of you are on this webinar because you may have a business situation or a teetering situation. But for the rest of us, the biggest liability risk is not malpractice. It's not even divorce, although you should be nice to your spouse today for a change. It is automobile liability. Don't let anyone drive your car but you, and don't drive your car under the influence of alcohol, marijuana, anger, while you're texting, which is even worse now. We have time and time again, week after week, every year, people who come to us who may lose all their assets because of a terrible automobile accident. The definition of concealment. Now, this is not what you do to your engine to keep the snow from penetrating into the engine. Concealment is when you lie because you say, this isn't mine, I gave it to my mother-in-law. Of course, wink, wink, she's going to give it back when I need it. I'll go bankrupt. I won't tell anyone about it. I'm glad I told my lawyer about it. Wait, that's illegal. You go to jail. You lose your discharge in bankruptcy. So don't think you can get away with that stuff. Do legitimate planning in advance, and you will be much better protected. Arguably, the best book ever written, How to Stop Worrying and Start Living by Dale Carnegie. When you are in these situations, Carnegie's book, written beautifully in the 1930s, almost unimprovable, tells you how to make decisions on how to proceed and how to let your mind work without worry plaguing you. Almost everyone on this webinar, there's always some 800-pound gorilla. No matter what we do in life, there's the main thing bothering us. That main thing bothering us, a lot of times it's fear over an event. And what Carnegie says is, think about how many times you've had that fear about something that you thought might happen. It didn't happen. You just wasted a lot of time and energy. But worse, the ostrich puts the head in the sand, doesn't take action. So many times clients come to us with a creditor situation, and after a half hour, 45 minutes in the conference room, two things become apparent. Number one, the client wasn't doing what they should have done to avoid the problem because they hadn't thought it through, they hadn't gotten the right advice, they hadn't been creative about it, they just hadn't been able to be sensible, or they didn't have the solution. Secondly, they worried a lot more than they needed to. They lost a lot of sleep, which causes you not to be able to handle the situation properly. Carnegie wrote this book before antidepressants were invented and before there were better forms of alcohol than there were in 1936. We all could use a dose of this book. I highly recommend it. Now, estate planning and creditor protection planning go hand in hand. When you do your estate planning, you're figuring out where things are owned, how things should be owned, where they pass on death, what happens if you become incapacitated. You should always link your creditor protection planning with estate planning. And for most of my clients, the estate planning was the creditor protection planning. And if and when asked, when and why did you do that? I did that in the normal course of my estate planning. It had nothing to do with avoiding a creditor. Things were going well. At the time I did it, I wasn't worried about creditors. I was worried about being responsible for my family. And while you're at it, page 9, we are in a COVID crisis. Make sure you have a healthcare power of attorney naming those people who would be able to make your healthcare decisions if you're not able to. One thing that bothers me about most healthcare powers of attorney is that they name one person and then they name alternates. If you trust these people, why wouldn't you put 3 or 4 people down? Whoever gets there first, whoever may be there at 2 in the morning visiting you when someone needs to talk to the nurse and look at the chart and ask them to call the doctor for you. So I have 5 people on my healthcare power of attorney with their cell phone numbers, with a notation that they will be paid very well if they will only assist me in time of need. The person, my first choice, may not be feeling well and may be quite upset. So we find that clients get better care when they name several people. The other thing I'm going to tell you, and I think a lot of medical professionals are on this call, so you understand this as well as I do. The parent says, I want my daughter, Tabitha, to be my healthcare agent. The intensive care nurse calls Tabitha. Tabitha says, I'm in a meeting, I'll call you later. The intensive care nurse calls Tabitha 2 hours later. Tabitha says, I'm sorry, I forgot. I'm getting my dinner right now, let me call you later. If the client had named 4 children, the nurse could call 4 children and might find one who's responsible. People get fooled, so just try to be careful. Page 10, the F. Lee Bailey rule. Any person who does his own legal work has a fool for a client. F. Lee Bailey was one of the best lawyers in the United States, ended up in jail because he made a mistake. There was something he did, he could have done it one way or the other, it would have had the same result. He did it the other way, and he ended up being hung by his own rule. Page 11, assuming that you do want to protect your assets from creditors, there are many ways to do this. And what you have to do, you really have no choice, is to, number 1, make a list of every single asset and exactly how it's held, what it's worth, how much you owe on it, where it's going to go if you die, and then identify which of these assets are protected from creditors under state and federal law, and which of these assets are not protected from creditors. And then guess what? Decide what you need to do to protect them from creditors. And even if you have an imminent creditor situation, there are things that you can do. For example, a lot of people come to me and they say, hey, I was told I couldn't do anything. I've got a trial coming up in 8 months, and I have all this money in this bank account. And I say, okay, do you realize that because you're the head of a household, your wages are protected from creditors and whatever you put them in will be protected from creditors? Yes, I do. Do you realize that you could be living on your savings and spending it down over the next 8 months in the normal course of living while you save your wages, and then by the time you get to the jury trial, there won't be anything for the creditor to get? And the client goes, oh my gosh, how smart is that? So there's always things you can do, or almost always things that you can do. They may not be as good as what they would be if you had planned ahead like Noah did, but oftentimes you can get good creditor protection results. You have to sweat the details. You have to put these things down on paper, preferably review them with a lawyer under the attorney-client privilege, not your hairstylist, not your barber, not even your CPA, because there's no CPA client privilege in bankruptcy. Your CPA can certainly help you prepare a financial statement, but you really want to get this strategy done with a lawyer who is familiar with this area. Even me, I've been doing this for 37 years. Not a week goes by that I don't get help from a subspecialist lawyer who's a bankruptcy lawyer or a healthcare lawyer or a security lawyer every week, sometimes every day. I don't pretend to know it all. No lawyer can know it all. So don't hesitate to get help from a real live bankruptcy lawyer. If not a bankruptcy lawyer, then usually a very good AV rated litigation lawyer or an AV rated estate planning lawyer who has at least tried to get expertise in this area. What do I mean by AV rated? I mean a lawyer who is rated AV by Martindale-Hubbell directories, or at least BV. We rate each other by confidential peer-to-peer surveys. That's the only service that I'm aware of that does that. It's been doing it for 120 years. It is fairly accurate. Now, as an example, many of you live in Florida, or maybe after hearing this webinar, you'll be moving to Florida. What's exempt from in Florida? Homestead up to half an acre within the city limits, up to 160 acres outside of the city limits, normally immune from a fraudulent transfer statute problem. None of these exemptions, by the way, apply to the Internal Revenue Service or in divorce or the Securities Exchange Commission or the FTC. So you've got to do other things if those are a concern, and it's illegal to evade payment to a federal agency. So you have to really be careful if you have a situation with the IRS or you want to pay the IRS first, and you don't want to do false advertising or violate FTC or Securities Exchange Commission rules whatsoever. Back to Florida law, your IRA is protected unlimited. Your cash value of life insurance is protected. Your tenancy by the entirety's assets, that's assets owned between you and your spouse, specially titled as tenancy by the entireties. That applies in Florida, Delaware, Wyoming, Vermont, and certain other states, not all states. And you need to check the box for tenancy by the entireties on the joint account. My partner Ken Crotty recently did a half-hour webinar on tenancy by the entireties protection. If you want a copy of that, if you want to view that, let us know. In most states, 529 college savings plans are protected, so why wouldn't you put money aside to pay for the college of your child or others who you can use that for? Annuity contracts, which can be very expensive or inexpensive depending upon where you get them, may be protected by your state law, are protected in Florida. And then finally, we see here the charging order. What is a charging order? Page 14, I have a single individual, not married. She owns her homestead, which is protected. She has a revocable living trust, which is not protected from creditors, ladies and gentlemen. A revocable living trust will avoid probate, will avoid guardianship, can protect the surviving spouse from creditors, but will not protect you from creditors. So she has a limited liability company that owns her securities. It is owned 97% by her revocable living trust and 3% by an irrevocable trust for her child. Now, you get a judgment against her, and you cannot reach into this LLC because of the Florida charging order rules, which says that the sole remedy of a judgment creditor against a debtor who owns part of an LLC is a charging order. A charging order is the order from the court which says that if you ever want to make a distribution from the LLC, You have to make it to the creditor. So you're at a stalemate. The creditor has a charging order, can't reach into the LLC. You have control of the LLC, you manage it, you may pay your wife a salary from it. You can buy things, sell things, but not take money out unless the creditor is paid. Normally, the creditor will settle when this type of situation happens. Another step in this protection, though, would be to take your 97% ownership of this LLC and put it in a Nevada creditor protection trust. Now, that may not work because we can't be sure whether Nevada law will apply to protect a Floridian in a judgment situation. We're not sure whether the full faith and credit clause of the US Constitution would apply. But then, even if the creditor can set aside the asset protection trust, all they're going to get is a charging order. And by the way, the asset protection trust may say that if there's going to be a judgment or a possible judgment against you, that trust will flee to an offshore jurisdiction like Nevis or the Cook Islands. The creditor may have to go there to set aside the asset protection trust. And then if they win that litigation in Nevada or Nevis, they still would only get a charging order. So for married people, though, and I'll see if I've got a married person example here. For married people, you could just put the assets in your spouse's name. See, I'm skipping a few slides to comply with my 30-minute rule. But here's spouse 1 and spouse 2, each with a revocable trust to avoid probate. Spouse 1 sets up a family limited partnership, is the controlling 1% general partner, gives spouse 2 the 99% limited partner interest. Spouse 1 is the neurosurgeon, spouse 2 is the soccer coach. Spouse 1 gets sued. They may be able to take 1% at most of this partnership. They can't take 99%. Or spouse 2 puts the 99% in a trust for spouse 1, rather, transfers the 99% to a trust for spouse 2 and the children. And as long as spouse 1 and spouse 2 are getting along, spouse 1 can live with spouse 2. Spouse 2 can receive benefits from the trust. And if the trust is in Nevada, the trust can say that if there's a divorce, it will divide into one trust, half of the assets for spouse 2 and half of the assets for spouse 1. So I know that I have covered a great many things here. There's much more to be covered, but life is short and Saturdays are few and far between. There's only one a week, 52 a year, and I don't want to take much more of your Saturday. I hope that you will request our Maui Mastermind webinar. It doesn't talk anything about Maui Mastermind. It was just custom made for Maui Mastermind and my friend David Finkel, who is a business coach. By the way, if you would like a free copy of David's book, Build a Business, Not a Job, or the book that David and I wrote with Dr. Singh, Grow Your Medical Practice, just send us an email and in the RE line, put the words GROW, G-R-O-W, for the Grow Your Medical Practice book, or BUILD for the Build a Business book. I will mail you that book, US mail, or I'll email it to you as a PDF, whichever you prefer. I hope that this was of some help to you. There will be a complimentary replay today at 5. Then we'll post this to YouTube. We always welcome questions, comments, and suggestions. Thanks again. I'm sorry I went 4 minutes over, and may the rest of your day be quite pleasant. And like I said, be kind to your spouse for a change, please. Marcia, are you listening? Thank you.